Okay, so I wanted to kind of go through this motion in limine document about the vague and undisclosed testimony because I noticed a lot of people have been breaking it down, but they have doing it in such a way that they're kind of ignoring the things that are actually good for the state. I noticed the people that have been breaking these documents down are focusing on what's good for Coburger. So I wanted to go through some of this and point out the things that I believe bolster the state's case. And I'm not going to go through every single expert that's listed on here, but just highlight the ones where it appears that maybe Anne was telling some tall tales and Hippler kind of straightened out what's what. So we're going to begin on page 3. And this is the section about Special Agent Balance. And it says he was primarily involved in the analysis of cell phone records in the investigation. He is disclosed to testify in the state's case in chief about his analysis of AT&T cell phone records for the defendant, Madison Mogan and Xana Kernodle, as well as his own drive testing measurements to determine the use and general location of their cell phones between June 2022 and November 2022. Accompanying his initial disclosure is his 30-page CAST report, which discusses and maps the data he reviewed and the methodology employed. Now, remember, Anne claimed he didn't include his methodology, and she made it sound like the report was nothing but graphs and not really a report. Hippler's making it sound like it's actually quite extensive. And it says his supplemental disclosure goes through each page of the CAST report to discuss its significance. So he added up in his supplemental disclosure. He will also discuss topics pertaining to how cellular technology works, particularly how cell towers operate and how cell phones connect to the towers, etc., etc. And if you look down below, it says the state submitted 3 disclosures. This is in the footnotes. 3 disclosures for Mr. Balance. The initial disclosure, which was December 18th, 2024. The rebuttal disclosure, February 17th, 2025. And the amended supplemental disclosure, March 3rd. In addition, throughout their case, the defense has had and been on notice of Exhibit A to the various search warrant affidavits which detail much of the opinion and analysis of the CATS team, and thus Balance, including those related to the defendant's locations at the outlined times before and after the homicides. So Hippler's basically saying, hey, defense, you've had this information, and you know what his opinion is. So now this is page 4, and we're going to pick it up where it's talking about Cy Ray's affidavit. And it says Cy Ray complains that he is unable to identify Agent Balance's methodology, which was described in the CAST report. Mr. Ray states that the CAST report omits data and or fails to mention how certain AT&T data was utilized in his analysis, namely handoff data and drive test mapping, and why some data was ignored. He asserts this omitted data and methodology is exculpatory, and without it, he cannot fairly analyze Agent Balance's work. And that is the first footnote down at the bottom here, footnote number 5. And I'm not going to read through that. You can pause and read through that, but it's basically the same information that was in Cy's affidavit that came out a few weeks ago. According to the state, its disclosures sufficiently identify Agent Balance's opinions and the facts and data he relied upon, and defendants' concerns are fodder for cross-examination. In fact, in Agent Balance's rebuttal disclosure, the state marches through each concern outlined by Mr. Ray, offering additional explanation about what Agent Balance considered, including the handoff data and why. So it sounds like in their rebuttal, they were very thorough. That Balance was very thorough, and Hippler is correct. This is cross-examination stuff. This is for if Cyree is still telling Anne he doesn't think it's sufficient, then Anne needs to cross-examination Agent Balance on how he came to these conclusions. And Hippler has been very clear that he wants the jury to hear a lot of these things and decide. It's not for him to decide what is going to be included. Defendant, however, asserts the attempted clarification in the rebuttal disclosure is insufficient, arguing there is no disclosure as to why he omitted 95% of the relevant coverage maps for his drive testing, no analysis or mapping of the handoff data, and no documentation provided of the cast report's peer review process. And we have another footnote 6. There is no requirement under Rule 16 ICR that the state provide peer review documentation of an expert's report. Likewise, the rule does not require an expert to identify the data they did not rely upon or why they did not rely upon that data. So basically, Cy was wanting to know why Balance didn't rely upon something and include that data, but there's no requirement that they include that, and also no requirement to show that it was peer-reviewed. Interesting. That figures that they would try to argue something that there's actually no requirement about. However, the fact remains that the defendant has all the facts and data that Agent Balance relied upon to form his opinions, which are expressed within his cast report. Footnote 7 says a draft of the cast report was first disclosed to the defense in the early stages of the case. It was subsequently peer-reviewed, and the final cast report was issued and disclosed in July of 2024. So Anne has had this thing since July of 2024, the final cast. And it was peer-reviewed. So even though they didn't disclose the peer review, they are saying it's peer-reviewed. And guess what? Per ICR, they don't have to disclose the peer review. So she's throwing spaghetti at the wall again. I understand that's her job, but wow. Let's see. So where was I on that? Footnote 7. Okay, cast report. The data supporting Balance's opinions is located in the files of the cell phone records provided by AT&T and the drive testing files which were provided to the defense through discovery. Okay, so it sounds like they received everything. So we're going on, and it says, while his methodology might not be set forth with as much specificity as Mr. Ray would like, Rule 16 does not require that detailed methodology be provided. It requires merely opinions, facts, and data for those opinions, and the witness's qualifications. To the extent defendant believes Agent Balance omitted important data or is relying on insufficient data for his opinions, this is fodder for cross-examination, not exclusion. Moreover, if an opinion is not reasonably set forth within the disclosure, it will not be allowed. And that is footnote 8. And it was talking about, let's see, it says defendant complained at the hearing that Agent Balance analyzed handoff data for the 7 minutes prior to the phone powering off. Oh, and Hippler said it again, phone powering off. Not that it was out of range. Let's see, 254 on November 13th. He did not provide an opinion about what his analysis showed. The defendant wants to exclude any opinion as to what his analysis of those 7 minutes showed. However, as pointed out in Agent Balance's rebuttal disclosure, page 13 of the cast report, sets forth the data Agent Balance relied upon. Interesting. So it says to opine that the defendant's phone used a certain tower and sector at 2:47 a.m. Southeast of his apartment and ceased communication with the network at 2:54. He also explains that the location of the device is best estimated by initial cell by the initial cell site versus the handoff cell site. He will be allowed to testify to these opinions. If defendant believes Agent Balance strays beyond these opinions, he can object and the court will take the matter up then. Interesting. So he's saying that he was southeast, not southwest, like Cy Ray is trying to claim. So this is truly going to be a battle of the experts. Now, next, we're going to go on to Heather and Jared Barnhart, and this information was different to me than what the past filings said, because the past filings simply stated that it was habit information. So I had done a video believing that the Barnharts were going to be talking about his cellular habits, but it's actually gaps in his PC and cell phone data. So this is an interesting one. Okay, so it says the Barnharts are digital specialists with Cellbrite who were retained by law enforcement to analyze defendant's cell phone and PC to determine user behavior and action. They are disclosed to opine that the gaps in data on the two devices were abnormal. Attached to the disclosures is a report jointly authored by the Barnharts detailing their analysis and findings. Wow. Their CVs were provided as well. The defendant argues that the disclosures indicate they will testify to habit evidence, which he complains is not explained and is not accompanied by any opinions. Defendant's challenge is confusing. Nowhere do the disclosures or the report indicate the Barnharts will testify about habit evidence. Rather, the disclosures state they will testify to their findings pertaining to the defendant's activities on his PC and cell phone for a period of time before and after the homicide, and why gaps in data over that time period are abnormal. That is very interesting. And there's a footnote that says specifically their report explains gaps in data may be consistent with cleaning up or using anti-forensic methods for to clear evidence. Interesting. So let's go on to the next page. So it said they observed gaps in his PC that may be consistent with cleaning up or using anti-forensic methods to clear the evidence. Among the gaps found were in the PC's event logs and system resource usage monitoring between November 11th, 2022 and November 16th, 2022, which Barnhart's opined was abnormal given that school was in session. Likewise, they located gaps in the PC's Chrome history during dates where downloads occurred on the system, indicating that the user was private browsing or clearing browser history. Together, the Barnhart's disclosures and joint reports set forth all that is required by ICR, and there is no basis to exclude or limit their testimony. Oh, that is going to be interesting to see what they believe was the reason for those gaps. Did he really go through and clean things out? And why on his work computer, his school computer, would he delete things during the semester? Like they said, while school is in session. That's going to be interesting. Okay, so now we are going to Michael Douglas. And Mr. Douglas is a forensic accountant for the FBI and disclosed to testify on financial transaction data for the 4 victims and 2 other roommates and the defendant. His initial disclosure identifies by category and date range the financial transaction data he intends to testify to and appends Mr. Douglas's report of specific transactions found within these individuals' financial data. His supplemental disclosure identifies more specifically the financial data associated with the defendant that he intends to discuss, and also identifies evidence obtained showing defendant's ATM withdrawals. It says, defendant contends that Mr. Douglas should not be able to offer any opinions because none are expressed in his disclosures. Specifically, defendant notes that Mr. Douglas's supplemental disclosure indicates he will testify to an analysis of the defendant's spending habits. Defendant takes issue with this, arguing there is no spending habit opinion disclosed. However, Mr. Douglas's disclosure makes it clear that he is intended as a fact witness and is only being disclosed as an expert in the event the court determines his testimony was based on specialized knowledge under IRE 702. Moreover, although the supplemental disclosure appears to indicate he will offer an opinion as to the defendant's spending habits, and his testimony will be limited to factual changes in how the defendant spent money. For example, the disclosure notes defendant only conducted ATM withdrawals on or after the date of the homicide and ceased using his debit card after November 10th, 2022. Whereas prior to November 10th, he had regularly used his debit card. Wow. Now that's interesting. There's no indication he will attempt to opine about the reason for the spending changes, just that they occurred. And then that is a footnote. It says, without more, the court has concerns about the relevance of his testimony, but defendant has not challenged it on this basis yet. So it sounds like Hippler does have a little bit of concern about that, but it sounds like they're not going to try to opine on why he changed that, so he's allowing it. Thus, there is no basis for excluding or limiting Mr. Douglas's testimony based upon disclosure concern. I am really curious. I don't know if maybe the rest of you aren't. I would hope some of you would be. Why would he change from doing debit card transactions to all of a sudden going and pulling cash out to make transactions? And why that week? That's interesting to me. What was it about November 10th that made him change from using his debit card at stores to pulling out cash to use instead? Maybe leave in the comments why you think he might have done that. Okay, so we got Shane Cox. He is the Amazon person. He will testify to the content of documents produced by Amazon and law enforcement pertaining to the Amazon account associated with the defendant. The documents include the order history between January 5th, 2022 and December 13th, 2022, and click history and sign-in history for the specific dates in that time frame. The documents are referenced by the Bates numbers. Now, of course, you'll remember there was the long back and forth with Hippler and Elisa Massoff over click history. And he is letting Mr. Cox testify about all that. So Hippler is saying that Cox is a fact witness and he will not be offering opinions, and therefore there is no basis for exclusion of his testimony. Next we have Darren Gilbertson. Defendant disclosed expert opinions from Brent Turvey that more than one assailant was necessary to accomplish the crime in the time frame alleged. Specifically, he asserts that 1, there is direct and indirect evidence that attempts were made by a suspect S to clean up the crime scene after the homicide, which would have taken longer than the time interval alleged by the state, and 2, there were multiple weapons used against Kaylee Gonzalez, and Xana and Ethan appeared to have been attacked at the same time. Turvey report, page 20. Well, that's again an expert opinion from the defense. We still have not seen the autopsies yet, so we don't know what the medical examiner concluded. We have a pretty good idea, though, that she probably concluded she believed it was one person, one weapon, because they only looked for one person and they continued to look for just one weapon. But we shall find out when we see all those reports. It says, through his other expert, Rachel Orr, defendant has also submitted evidence that he suffers from developmental coordination disorder, which has resulted in deficits in the fine motor dexterity and visual motor. We'll catch up on that on the next page. I just wanted to see what this footnote is. Oh, okay, it doesn't really tell us much in the footnote. Okay, just about the rebuttal disclosure for Detective Gilbertson. So let's go to page 8. Okay, so his motor function. His attorneys have argued in other motions that these deficiencies, that these deficits render it not possible for Mr. Koberger to have acted with the speed and coordination required to commit the crimes in the time frame alleged by the state. However, this has not been disclosed as an opinion of any of his experts. Wow. So what that's saying is that Anne is saying this, but that's not the opinion of any of the defendant's experts, that his motor skills and coordination actually would have rendered him unable. That's an interesting distinction there. And I notice nobody's really pointing that out. All they're talking about is how expert witness Turvey is going to say he couldn't have done it, that it must have been multiple suspects. I think this is kind of important, that the witnesses or the experts that are going to talk about Koberger's coordination of motor skills didn't say he wasn't capable. In rebuttal, the state disclosed Detective Darren Gilbertson, a lead investigator for ISP in this case. The disclosure indicates he will testify that he and other investigators conducted time runs at 1122 King Road to gain an understanding of the approximate time needed to have carried out the homicide. A report of the timed runs is attached to his disclosure. It was performed to determine if one person could carry out the homicides. His opinion will be that, depending on the suspect's pace and route, he could have carried out the crimes in approximately 2 to 4 minutes. And thank you, what have I been saying? When this first all happened and we got the time frame when the PCA came out, people were like, there's no way that's not possible. And I was like, he could have been in and out in 5 minutes. I'm like, it takes less than 60 seconds to stab someone to death, especially with a knife like a K-bar, and not even that size knife. If you look at the Apple River stabbings, how quickly that guy stabbed those 5 moving teenagers. It takes less than a minute, especially if you have people in close proximity. Look at the Sydney Mall stabber, the Brentwood massacre, a lot of these stabbing attacks in China and Japan, where people are in an enclosed space. So in this situation, you had Maddie and Kaylee in one room, Ethan and Xana in another. That doesn't take much time at all. All right, moving on. Defendant argues that Detective Gilbertson's testimony should be excluded because, 1, the state has failed to disclose how Detective Gilbertson is an expert in timed runs. 2, the relevance is minimal. I'd say it's pretty relevant. 3, important data, i.e. recordings, photographs, and notes of the experiment were not disclosed. And 4, his opinion carries a risk of juror confusion and prejudice. On the prejudice issue, defendant claims Detective Gilbertson was already familiar with the house when he did the experiment, and additionally, the house had been vacated. Defendant also notes the house has been torn down, so he is not able to conduct his own tests. Yeah, here's the thing, though. They could have conducted those tests before the house was torn down. There was nothing stopping Anne from doing those things. Whether Detective Gilbertson's opinions are relevant will depend on what Mr. Turvey and Dr. Orr opine at trial. Footnote. The court has indicated in a separate order that there is no foundation at this point for defendant's assertion that his deficits in fine motor dexterity and visual motor function rendered it difficult or impossible for him to have committed the crimes. Yep, see? His experts haven't stated that he couldn't have, which is very interesting. While Dr. Turvey does not specifically state in his report that one assailant could not have accomplished the murders in this short time frame alleged by the state, he infers as much, though, through his opinion that there was evidence of cleanup efforts at the crime scene, which would have taken a significantly longer period of time. Further, while Dr. Orr's report does not opine as to what deficits in fine motor dexterity and visual motor function defendant suffers from, to the extent she testifies to those deficits at trial, it may render Dr. Gilbertson's opinions relevant to rebut any inference that the defendant could not have single-handedly committed the crimes in less than 15 minutes. Yeah, I find that interesting. So Turvey actually doesn't rule out that it could have been one assailant. That's interesting right there. Further, given Detective Gilbertson's role as lead detective for ISP in the investigation, he is well qualified to offer his opinion on suspected movement throughout a crime scene. In addition, there does not appear to be a disclosure violation due to the lack of underlying data. It was a simple experiment consisting of timing. Detective Gilbertson moving through the house at a slower speed and a faster speed. His routes were described as well as his pauses to simulate the number of stab wounds each autopsy showed. It does not appear there are any photographs or recording or any other data not already described therein. As for defendant's IRE 403 concerns, they are baseless. The state represents that there were no structural changes to the house when Detective Gilbertson performed his experiments. The fact that it was vacated, or that Dr. Gilbertson was familiar with the home, which would presumably allow him to conduct a faster timed run, is fodder for cross-examination, not exclusion. The state further notes that the defendant stipulated to the house being torn down after Detective Gilbertson's report was disclosed. Thus, any concerns of prejudice in this regard is his own doing. Finally, defendant cites no basis for jury confusion. Consequently, Detective Gilbertson's disclosed testimony will not be excluded or limited at this time. Yep. See? What did I say? She went ahead and agreed to having the house torn down, and she could have run her own time tests before that house ever got torn down. And she was so concerned about all that, she should have never agreed to let it be torn down to begin with. I mean, this is just crazy. Okay, I'm not going to go over the lab scientists, their testimonies being allowed. A lot of that's been rehashed already, including at the hearing. I'm going to go to Gary Dawson, and that's on page 10. It says Dr. Gary Dawson was disclosed in rebuttal by the state to testify to the degree of impairment of the victims, particularly Madison Mogen, at the time of the homicide. His expert report attached to the disclosure opines that Madison Mogen would have been markedly intoxicated from the effects of alcohol around the time of her death. She would not have the ability to mount a meaningful response to a sudden threat to her person. And that says his report, page 3. He further states that while he has limited his review to Madison Mogen, the same general principles apply to the other victims. Defendant seeks to strike his testimony on grounds that it is improper rebuttal. He contends that none of his experts have challenged her ability to fight back or otherwise contested her toxicology levels. The state responds that the opinion rebuts the defense expert Brent Turvey's opinion that more than one assailant was necessary to accomplish the crime at the time frame alleged. Specifically, the state argues that evidence that Ms. Mogan was unable to effectively fight back supports the position that one assailant could have completed the homicides in a short time frame. So basically, they're saying because she was so intoxicated, she didn't fight back, so one person could have easily come in and had the upper hand there. Oh, I did want to mention something about the lab, though. If you look down here on this footnote that I've highlighted down in the footnotes, let's look at this real quick. So this talks about the CODIS eligibility. And it says to the extent that Jade Miller's supplemental disclosure and Catherine White's rebuttal disclosure contain discussion of CODIS, how it works, how CODIS eligibility is determined, and why the decision was made not to enter certain profiles into the system. Defendant objects that it is new, ultimately opinion. However, the court does not view this discussion as opinion. Rather, it is purely factual issue. Rather, it is a purely factual issue explaining reasons why certain decisions were made consistent with CODIS rules and limitations. In addition to the extent the defendant contends that these facts were not timely disclosed, defendant has had plenty of time between their disclosure and trial to address them. Now, see, that's what we're talking about. People are saying, well, how can they just choose not to run the DNA that was on the glove or the DNA on the handrail? It's not that they chose not to run them. It's that the guidelines do not allow them to run certain things. And I imagine this will get explained in detail during the trial. But you can see right here, it's not an opinion matter. It's a factual issue because those decisions were made consistent with CODIS rules / limitations. Also, it sounds like the defense is known for quite a while why those profiles weren't ran. Okay, this is following up on the rest of Gary Dawson. It says, rebuttal evidence is evidence which explains, repels, counteracts, or disproves evidence which has been introduced by or on behalf of the adverse party. And it brings up case law. Mr. Turvey has opined in his report that 2 assailants were involved in the homicide, partially because he believes multiple weapons were used against Kaylee Gonzalez. Inferred in this opinion is that one person would not have had the time or ability to use multiple weapons in the time frame alleged when faced with 2 victims. If Ms. Mogan was intoxicated to the point of being unable to fight back, however, it would be possible for one suspect to incapacitate her and then use multiple weapons in attacking Miss Gonsalves. However, whether Dr. Dawson's opinion is relevant depends on how Mr. Turvey's testimony unfolds at trial. Consequently, his disclosed rebuttal opinion will not be excluded or limited at this time. Now, I thought it was interesting they brought up multiple weapons, and I'm wondering if the injury to her face, because Steve said she was punched. The aunt had also mentioned that she was punched. So I'm not so sure if it was multiple weapons, but just multiple methods of injury. So he stabbed her and punched her. And again, we will find out more based on the autopsy reports as to if 2 weapons really were used. Okay, and I'm not going to go through the Mowry, Uric, Henzola section. I'm going to skip ahead to Rob Healy. So here we go with Agent Hilly. He's a special agent with the FBI who reviewed surveillance footage from the hours before and after the homicides occurred, depicting what law enforcement believes is suspect vehicle 1. Agent Hilly was disclosed to rebut opinions by defense expert Stephen Becker that it was not possible to ascertain from the surveillance videos whether a front license plate was missing from the vehicle. So the defense is trying to claim you couldn't tell that. Agent Hilly's rebuttal references the full summary of video depicting Suspect Vehicle 1, which has been closed to the defendant, as a basis for his opinion that Suspect Vehicle 1 did not have a front plate. He then lists the specific camera locations and timestamps he contends show a clear view of a missing front plate. His rebuttal also states he will provide testimony about the significance of the missing front plate. Defendant contends that since Agent Hilly has not offered an opinion as to any videos other than the specific clips referenced, his testimony must be limited to those identified clips. However, Agent Hilly's disclosed opinion is not restricted to the identified clips. It expressly is based on the full summary of video of Suspect Vehicle 1, with the identified clips being the most clear. Thus, the court will not limit his testimony in this regard. Okay. So it sounds like Anne was not being the most truthful with us again, because she tried to claim in her motions that it wasn't clear. And if you notice, she also picked out a couple pictures to put in her documents where there was glare from the headlights. And I had a lot of people saying, oh, look at those, you can't tell if there's a plate or not. That's the quality of the video. And I'm like, but how do you know? Because that's only screenshot from like 2 videos. And there's plenty more videos. And I'm like, the FBI is saying there's clear pictures that show no license plate. And, excuse me, people tried to argue that with me. And, oh, look at this. Agent Hilly has videos that show no front license plate. How about that? So, very interesting indeed. And of course, Hippler went on to basically say he was not precluding any of these people's testimony at trial. So, buck up, folks, because we're still in the midst of everything getting really interesting before trial. And as usual, leave any questions, comments, concerns down in the comments and let me know if there's something else you'd like me to go over in depth.